Hello and welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our Valentine, eDiscovery Today's Doug Austin. It's called Important eDiscovery Case Law Decisions for February 2023, and our faculty experts are none other than Doug Austin, the Honorable Andrew Peck, and Tom O'Connor. We welcome your questions and feedback in the console. This webinar will be recorded and available for replay at your convenience, as are all of our webinars. Kaylee Wallstead, EDRM's Chief Strategy Officer, is here with us today. What do we have for resources?
Happy Valentine's Day to our wonderful community and our fabulous presenters today. For resources, if you look to the right of your console, you'll see a paperclip. First is up next on EDRM's webinar channel, February 28th. What's a document? RIM technology from Egyptian ostraka to modern attachments with the always brilliant Ken Withers of the Sedona Conference. Next, check out Tom O'Connor's always spicy techno blog at the link. And you can learn more about the Honorable Judge Peck and how you can engage with him. And download a copy of EDRM's Professional Responsibility Considerations in AI for eDiscovery Competence, Confidentiality, Privacy, and Ownership, which is now out for public comment. And last, EDRM and our trusted partner iPro have just dropped a flash survey for Valentine's Day on what you love the most about eDiscovery and what breaks your heart. It literally takes 2 minutes. So we hope you all will take a second to do that. And back to you, Miss Mack.
All right. And at the end of our webinar, you can download a certificate of attendance from the Counsel to use for your continuing ed requirements. And so Doug Austin is the founder and editor of our EDRM trusted partner, eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010 and has earned JD Super Awards 3 times. And the great Tom O'Connor, hailing from the Mardi Gras city of New Orleans. There we go. For over 3 decades, he has stewarded the Gulf Coast Legal Technology Center, has a wonderful YouTube channel for long-form interviews, and he's a sought-out consultant on some of the largest cases. He's written the book on eDiscovery for the rest of us and cooks a fabulous crawfish. And the Honorable Judge Andrew Peck. He's a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as the United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions, and even later on boilerplate objections and 502D orders, and of course, TAR. And we're very grateful for all 3 gentlemen for serving on our EDRM Global Advisory Council. Doug, do we have some cases to talk about today on this day of Valentine's?
We do indeed, Mary. Thanks, and happy Valentine's Day, everybody. To paraphrase a t-shirt in the famous Lester v. Allied Concrete case, we heart hot cases. And we have 6 interesting and unique cases to cover this month, including declaration of a deposition location as via Zoom, motion to compel disclosure of search terms, authentication of Wayback Machine evidence, possession, custody, and control of vendor records, discovery of ESI from an Apex custodian, and adverse inference sanctions regarding ESI and Basecamp. And just a reminder, we do welcome questions, and we will try to get to as many as we can, so certainly put them out there. And we will send out a copy of the slides after the presentation, so look for that too. That's our little Valentine to you. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners, which I think is one of the love languages for lawyers.
Ouch.
And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 27,700 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. And here's something I never thought I'd say to introduce a case. It's hammer time. At least that's what California Magistrate Judge Mitchell Denman thinks. In this insurance coverage dispute concerning defendant's claim for loss of business income under a commercial insurance policy, the plaintiff had a lot of trouble getting on the same page and deposing non-party General Dynamics ordnance and tactical systems. First, they didn't seek to depose a corporate representative until less than 6 weeks before discovery closed in the case, but that subpoena was incorrectly directed. At one point, the plaintiff and GDOTS considered a declaration in lieu of a deposition, but those negotiations failed. Ultimately, GDOTS refused to appear for the deposition, leading to the motion to compel. GDOTS challenged the court's jurisdiction to consider the motion to compel, arguing that plaintiff should have filed it in the Middle District of Florida because GDOTS has its corporate headquarters in St. Petersburg. They also asked the court to quash the amended subpoena pursuant to Rule 45D3 because it failed to provide a reasonable amount of time for GDOTS to respond, failed to comply with the geographical 100-mile requirements of Rule 45C1A, and was unduly burdensome. Judge Denman stated, FIC does not dispute that GDOTS's principal place of business is Virginia and its corporate headquarters is Florida. Unquestionably, the Southern District of California is not an optional place of compliance under that analysis. To consider the place of compliance identified on the face of the subpoena, the court looks more closely at the amended subpoena itself, and to which he stated a valid subpoena must list a specific place of compliance pursuant to Rule 45A1A3, adding the amended subpoena lists the place of compliance as via Zoom video conference. A Zoom video conference, however, is not a place. So he denied the plaintiff's motion to compel, stating, to quote MC Hammer, this court simply can't touch this. So Tom, why is it such a big deal where the place of compliance is? Why can't it be via Zoom since we're doing so many remote proceedings via Zoom these days?
Well, it could be. The big deal here is that the rule, as you just quoted, is very specific about naming a place, meaning a physical place. And the as I understand it, the goal of that is to lessen burden on people having to comply with the subpoena and travel all over the place. And in this case, it didn't name either of the two places where the in the words of the rule, the company regularly does business. But as Judge Denman pointed out, they could have agreed to do it. That would have solved the whole thing if there had been a little bit more cooperation amongst the parties. One of the areas where the cooperation proclamation could be brought to bear, they could have agreed to do it. And then everybody would have been fine. I suppose they could have tried to say, we're going to have a deposition or a subpoena is going to be served and you should appear at the location in either Florida or Virginia, and we will attend by Zoom. That's probably a little bit of a smarmy attempt that would have failed as well, but it would have been interesting to see. I should note too, real quickly, Judge Denman didn't just pull a musical reference out of the air here. I've had the pleasure of meeting him a number of times. He was one of the co-founders, along with our old friend Browning Marian, of the ESI Forum in San Diego, a monthly meeting on eDiscovery that they hold at the federal courthouse. And he is himself an accomplished musician, singer, songwriter, guitarist with a number of CDs to to his credit, the latest, and I don't get a royalty on this, Nothing Up My Sleeve, is available on Apple Records for your listening pleasure. Mitchell Denman. Thank you, folks.
All right. Well, Tom, I had no idea. I've learned so much about Judge Denman. So, certainly you point out a couple of interesting, considerations. So let's start with the rule. And Judge Peck, certainly with the ease of conducting so many types of proceedings remotely, including depositions, do you think we'll see rules changes to accommodate parties who want to conduct them remotely?
I think the answer to that is no. But even if it were yes, remember the rulemaking process takes a minimum of 5 years from when any of the advisory committees on the rules start thinking about a rule change, then going through public comment, et cetera, et cetera. It's a 5-year process. By then, 5 years from now, Zoom may be a thing of the past. But in any event, it can be, remote depositions are quite possible. Rule 30B4, not our old friend 30B6, but 30B4, the general rule for location of depositions, and it's carried forward in Rule 45 for subpoenas as well. But it says the parties may stipulate, or the court may on motion order, that a deposition be taken by telephone or other remote means, close quote. Now, right away, when it says by telephone or other remote means, we're looking at ancient language. But if as Tom was saying, if the parties had stipulated to a video deposition, and by parties when dealing with Rule 45 means the non-party witness as well, could have been done. We've all seen, because of COVID, that if you go to court and you have a good reason for doing a remote deposition, the court is going to allow it even over the other side's objection. We covered a case, I don't know how many months ago it was now, where one of the parties wanted to make the opposing counsel fly across the country, twice within a very short time period. And the court said, no, be real. You're going to do it by Zoom or the like. So I would say we don't really need a rule change. There has to be a, plausible reason to do it remotely, or there has to be a really good reason why remote won't work. But in any event, you got to name a physical location in the subpoena and then say, but it will be conducted by Zoom. You can't just say it's a Zoom deposition, so it can be anywhere in the country we decide to bring the subpoena and then the motion.
Okay. Yep. The case you talked about, I believe, was about a year and a half ago. It was our friend Illinois Judge Cole, as I recall. So that was a good one at the time when the Delta variant was raging, and he was pushing them to agree to remote depositions. So yeah, that was a good one for sure. So Mary, as Judge Denman and Tom noted, the parties didn't agree to a remote video deposition here. So why do you think the deponents would object to conducting it remotely?
Well, before I go there, Doug, the thing about this I thought that was interesting is they said the Zoom link would be forthcoming later. So there really wasn't a place. Not that it would make a difference in this case, but it might make a difference in other cases. So why wouldn't you want to do a remote depo? Well, they may want to observe the demeanor in person, not just the top half of a body. And they may feel that the other side might help the deponent in ways that they couldn't if it was in person. They may not be tech savvy with the appropriate equipment or bandwidth. And then the uncharitable reasons would be to drive up expenses and to stretch the time out.
I'm shocked to think that you would think any lawyer would want to drive up the other side's expense. Just shocked.
Well, I know, saying the quiet stuff out loud. So sorry.
Indeed. Well, that's certainly a reason I can see, even if it's not talked about. So thanks, Mary. We'll move on to our next case. We do have somebody who does seem to be not hearing us, I guess, because they're asking about whether this has started. I wish I could tell you, get to you somehow with a message, but hopefully you'll catch us eventually or via recording.
Doug,
yes.
I reached out to support for them. So
okay,
yeah.
perfect.
Yeah.
Okay, thanks, Mary. So our next case involves claims of false advertising, trademark infringement, and copyright infringement, among other things. Here, the defendant sought an order compelling plaintiff to disclose the sources, methodology, and search terms used to collect emails and other documents from the plaintiff's president, John Saharic, after Saharic's deposition testimony that, although he expected to be notified if any documents, emails, or ESI in his possession were collected from him in connection with the case, he was unaware of any such collection. Plaintiff opposed the motion on the grounds that it properly conducted discovery on Saharic's documents and that no deficiency in plaintiff's production was demonstrated by defendants. California Magistrate Judge David Leshner began his analysis by noting, unfortunately, it is apparent that parties did not engage in a fulsome meet and confer regarding the ESI checklist items, including relevant search terms, at the outset of this case. Plaintiff's opposition attaches correspondence between the parties regarding search terms that appears to postdate plaintiff's document production. And at a discovery conference on December 16, 2022, concerning another discovery dispute in the case, counsel for both parties affirmed that they did not meet and confer regarding search terms prior to propounding discovery or producing documents. As for discovery of search terms used by plaintiff, Judge Leshner stated, discovery into another party's discovery process is disfavored, and requests for such meta-discovery should be closely scrutinized in light of the danger of extending the already costly and time-consuming discovery process ad infinitum. Generally, courts will only permit such discovery where there is some indication that a party's discovery has been insufficient or deficient. This was not one of those cases, as Judge Leshner stated. Defendants have not shown that plaintiff's collection and production of Saharic's emails was insufficient or deficient. As such, the court will not compel plaintiff to produce the search terms it used to locate Saharic's emails that were responsive to defendants' request for production. So, Judge Peck, we continue to see judges call out litigants for failing to fully meet and confer, even though it's in the rules. What can be done to get parties to take the meet and confer seriously, and what would you do if you were still on the bench?
Well, obviously, one solution is to say, too bad you had this slot on the calendar. You didn't meet and confer, or didn't meet and confer adequately. Go out, meet and confer, and come back when I next have a chance to see you in a month or two. That is the balance that a judge has to make between efficiency. You sent me enough information, I can resolve the dispute. Let's just do it, versus if you let parties skate by the meet and confer, that's not training them for the long run, or training other lawyers who read the decisions. There's also a slight risk depending. I had one case here at DLA where at every meet and confer, the other side said, oh, you've made some interesting points. We'll think about it and get back to you. We're not at impasse, so you can't go to the court. And that went on for way too long. So there's that risk. You can hit the party one or maybe both, and then you don't know, whether that's being fair, with a financial sanction. Pay $500 to the clerk of court for not having done your meet and confer. Finally, there is the old Magistrate Judge Dave Waxy approach, and we haven't been hearing this as much as we used to with Dave's retirement from the court. But he would tell parties, you didn't do a good meet and confer. You're each saying the other said something that they're denying. Go out and redo your meet and confer, videotape it. And if you can't resolve the dispute, send me the videotape. He said he never got a videotape back. That threat made them behave themselves. Now, that may be something about Kansas City, because I did tell the story way back when to one of my New Jersey counterparts who thought that was great till she got a 2-hour video back from the parties of their meet and confer. And she was ready to kill me for having to sit there and watch.
That's funny. Interesting approach. I like it. So, Mary, another thing interesting about this case is that the plaintiff's president wasn't even aware that his ESI had been collected. Do you think that's going to become more common with so many data sources in the cloud these days?
Oh, absolutely. A lot of times the ESI is just up there. So, he would not necessarily know about being collected. Is probably a frequent flyer in lawsuits, as a president, his material being collected a lot. But you would think from a process standpoint, before you'd put someone on the stand or have them deposed or something, that you would brief them on what had been done with their data. But yeah, that's just interesting. But it isn't that unusual, I think, when IT and legal doesn't talk to each other all that much, that the ball would get dropped on notifying custodians, especially if they're higher in the hierarchy, that their material had been collected. No one likes to ask the president or CEO for their laptop or their phone. No one probably wants to tell them they siphoned stuff from the cloud.
Yeah, fair point for sure. So, Tom, do you think the defendants shot themselves in the foot by not requesting information on searches sooner, or would it not have mattered since that's still discovery about discovery?
Well, a little bit of both. I think they shot themselves in the foot. Both of them did, by not having a meaningful meet and confer.
Right.
At which search and request for information to search would have hopefully been discussed. So I think that's the egregious error, if you will. I think, however, your second part of your question is also relevant in that this was, as the judge called it, information or a discussion about what he called meta discovery,
Right.
And talked about how to do that and why it's generally disfavored and so forth and so on. So I think that discussion would have been held regardless of what had been agreed upon in the meet and confer. But certainly there would have been a way, hopefully been a way to avoid this or get it out in front of the court a lot sooner, if nothing else.
Yeah, absolutely.
In going to the court, you have to follow that ancient constitutional doctrine, the Goldilocks doctrine. If you take it to the court too soon, whether because of a lack of meet and confer or other reason, the court will deny it. If you do it on the eve of trial or the close of discovery, then it's too late and the court may deny it on that ground. So,
Right.
like the baby bear, you got to get the porridge when it's just right.
If I can channel my inner Judge Denvin, you don't want to make your move too soon, right?
Right. Indeed. Very good. All right. Yeah, great point. Great analogies all around. So we'll move on to our next case. First, in response to the question, yes, the slides will be made available after the webinar. You'll get an email with a link to those and to the recording of the webinar as well. So look for that. So our next case involves a battle of objections over proposed trial exhibits that weren't disclosed in discovery. We're going to focus on one of those as it relates to authentication and ties into a case we discussed last year. In fact, it was in our top cases of the year. Here, the defendant sought to strike exhibit SB3, and the affidavit for SB3 was made by a records request processor at the Internet Archive, aka the Wayback Machine. The affidavit described the process by which the Wayback Machine archives internet files and makes them accessible to visitors to the website, and the affidavit attested to the authenticity of the archive screenshots attached as exhibits to the affidavit. The plaintiff asserted the affidavit was provided as a certificate of authenticity of the attached Wayback Machine records, as was specifically contemplated by the Fifth Circuit in Weinhofer v. Davy Shoring, where the Fifth Circuit ruled that Wayback Machine evidence is not self-authenticating, and that was the aforementioned case we discussed last year. Regarding the affidavit, Mississippi Magistrate Judge Roy Percy stated, the affidavit's description of the Wayback Machine's processes contains no substantive testimony regarding issues relevant to the claims or defenses in this case. The information goes towards the authenticity of the attached screenshots and nothing more. He also said, in denying the defendant's motion to strike the proposed trial exhibit, Sensory Path provided the subject affidavit to Fit and Fun in advance of the pretrial conference, which was conducted over 30 days before this case is set to be tried. The court finds this constitutes reasonable notice in this case. This does not mean that Fit and Fun may not still challenge the authenticity of the attached screenshots. It means only that the affidavit was provided sufficiently in advance of trial to give Fit and Fun reasonable notice of Sensory Path's intent to use it to authenticate the attached screenshots. So, Mary, unlike the Weinhofer case last year, the evidence here was accompanied by an affidavit and allowed, at least as a trial exhibit. So what, if anything, could a party do to authenticate evidence like this if they're unable to get an affidavit?
Well, if you can't get the affidavit, you might try a request to admit. You might try the testimony aspect that was allowed in the Weinhofer case in the depot or on the stand. And then you also may want to take a look at those screenshots, take a look at the website, see if they're the same, and then if they're the same, recollect them and get an affidavit.
Sure, that makes perfect sense. So Tom, in this case, both parties objected to proposed trial exhibits that weren't disclosed in discovery. So what advice do you have for our audience on getting exhibits allowed that weren't part of discovery?
Well, I think that's going to vary widely according to the court and the particular judge. Here in the Northern District of Mississippi, in front of Magistrate Judge Percy, he made it pretty clear what the standard was. You know, they garnered the affidavit 30 and provided it to the other side 30 days before, he said in advance of the pretrial conference, and the pretrial conference was set to occur 30 days before the case was to go to trial. So, you know, advance notice, I guess, is the watchword. But I think you want to make sure, depending upon your court, if you can find out, does the judge you're appearing in front of have any particular bench rules or previous decisions on this issue? And are there any local rules about it as well? I suspect it's going to vary widely. I'm not sure. Judge Peck can probably address this better. I'm not sure other courts are going to be as relaxed, shall we say, as Judge Percy was in allowing this.
Okay, fair enough. So Judge Peck, while allowing the affidavit and evidence to be used as a trial exhibit, Judge Percy still opened the door for the defendant to challenge the authenticity of the evidence. So how could they do that successfully, given there's an affidavit in place?
Well, the affidavit just means this was collected by the Wayback Machine on such and such a date. So perhaps that date was, after the time in question in the lawsuit, or was way before the time. So somebody from the party could have come in and testified at trial that this isn't what the plaintiff would have seen because we changed what the website looked like after that. And other, factual based issues, or maybe the Wayback Machine accurately captured the website, but didn't capture all of the pages of the website, and that a different page on the website would have changed what was seen by a party or anything else. And also, just going back to what Tom was saying, yes, local rules and judges' chamber rules are important, but don't forget the federal rules of civil procedure. 26A, the mandatory disclosure rule, says that if you haven't identified a witness or a document or evidence in your 26A disclosures, unless it has otherwise been on notice to the other side through discovery, that you can't use it. And it's, a black and white rule under 26A and one of the 37 parts that you don't identify it there, and you should have you can't use it, period.
Got it. Yeah.
All right.
Good point.
Yeah, absolutely. Great information. All right, so we will move on to our next case. If I can get my mouse to work here. Here we go. So this next case is a personal injury case involving claims from injuries allegedly sustained by the plaintiff on defendant's vessel when he slipped on stairs he contended were not properly constructed of and or treated with a sufficiently maintained non-skid tread surface. The plaintiff's September 22 letter requested that Steamship Authority produce documents related to the tread identified in the answers to interrogatories. During discovery conferences, the Steamship Authority refused to produce the documents on the grounds that they were in the possession of a third-party vendor. In other words, don't tread on me. The plaintiff contended that even if such records are in the possession of the third-party vendor, those records are in the Steamship Authority's possession, custody, or control under Rule 34A, and that these documents were crucial to his understanding of the tread in question. The Steamship Authority contended that while it can make a demand for the tread records from the third-party vendor, such a demand does not constitute control under Rule 34A, and also contended that because the plaintiff could subpoena the documents from the third-party vendor, the Steamship Authority was under no obligation to produce them. Massachusetts District Judge Indira Talwani initially noted that the Steamship Authority has not properly objected to Lynn Harris's Rule 34 request for the tread-related documents where on the record before the court, it appears that the Steamship Authority has made its written objections for the first time in its opposition to the motion to compel. But even if the objections were proper, she noted they weren't warranted, stating a document is under a party's control when that party has the right, authority, or ability to obtain the document upon demand. While the Steamship Authority refutes Lynn Harris's contention that the Steamship Authority has the right to demand the records at issue, nothing in the record suggests that the Steamship Authority, as a customer of the third-party shipyard servicing the vessel, does not have the practical ability to obtain the service-related records. The Steamship Authority's second argument that it is under no obligation to produce the records because Lynn Harris could subpoena the documents from the shipyard himself is unavailing. So she ordered Steamship Authority to produce the third-party vendor records. So, Tom, if you were the plaintiff, would you have gone ahead and issued a third-party subpoena to the defendant's vendor just in case the motion to compel was denied?
Well, probably not. I'm not sure that one wouldn't have gotten in the way of the other. The other problem with the subpoena is, if I recall correctly, you have up to 14 days only up to 14 days to object to the subpoena. But when you do that, it brings everything to a grinding halt while you argue that out, which could take forever. I've been involved with a client who's had several of these disputes, and we usually like to just get right in front of the judge with a motion and try to resolve this whole issue of custody and control right away. So I would have been more inclined to proceed the way they did.
Mm-hmm. Okay. So let's talk about the vendor here for a moment. Judge Peck, does the vendor have any rights in this situation to object to discovery, or do they have to comply because the evidence is considered in the possession, custody, and control of their client?
They don't have the ability to object on relevance grounds. They're not a party. Relevance is a party issue. But they certainly can object on the grounds of burden and proportionality. So, they might have objected and said, don't bother me as a non-party, get it from the party. But they also could have said, what do they need 5 years of inspections before the accident? If the inspections in the 6 months or year before the accident said there was something wrong or something right with the stairs, what do you need 3.5, 4 more years worth of that? So those are the sort of grounds that they could be objecting on.
Okay, interesting. So, Mary, when a vendor has responsive evidence and provides services to one of the parties, is that evidence always considered to be in the possession, custody, and control of that party, or does it depend on certain factors?
Well, that's an eDiscovery provider's worst nightmare, getting subpoenaed for their client data and having to address that. I think generally, yes, it's under the party's control, but some of that will depend on contract. Sometimes the contracts are with the law firm representing the party, so that they're under the law firm's direction, and so you have to look at that. Is there a service level, a response time specified? Is there a cost for defending against these kind of things? What happens if the provider's bill isn't paid? Do they still have to do things? I imagine with a court order they would, but must the provider notify or even defend against the request or the subpoena? And then are there any costs for putting things on legal hold? I mean, they're on legal hold anyway because it's evidence, but this is, in the early days, that was one of the blocking factors for organizations trusting third parties with their data. They thought that it would be able to be subpoenaed outside of their purview. So contractual provisions were written to make that very difficult.
Interesting.
I also want to add, it depends on the jurisdiction you're in as to what is the standard for possession, custody, or control. As we've talked about over the years with other cases, if you're in the Ninth Circuit, the standard is the legal right. So unless the defendant had the legal right to get the information from the vendor, it would not have possession, custody, or control. In other jurisdictions, notably the Second Circuit, the test, as the court used here, is the practical ability test. If you have the practical ability to request to get the information from the vendor, you have possession, custody, or control of it. And I will just note that the decision that the judge here relied upon was a 2007 Southern District of New York decision entitled In Re NTL, an absolutely brilliant decision that then magistrate judge. And I think you can all guess that, yes, that was me being immodest. That was my decision in NTL.
I had not picked up on that. Very interesting. Well, there you go. And because it seems to me like we have had a couple of cases that were handled differently. So I assume that must be the district that they, the circuit that they came from. So very interesting information. And thanks, Judge Peck, for that, and also for providing the case that provided some foundation to this case. And we'll move on to our next case, which is a case with a new term I hadn't heard before. The case alleged violations of the North Carolina Residential Rental Agreements Act related to quality and maintenance of privatized military housing at Fort Peck, North Carolina. The plaintiff's motion to compel defendants to begin document custodian and search term discovery sought relief on two issues, the second of which was that plaintiffs wanted John Persern, defendant's past president, to be an additional custodian included in the search term-based discovery. Defendants contended that Persern was an apex custodian, and plaintiffs had not made a compelling showing that all of the lower level designated custodians weren't sufficient to capture the necessary information, also claiming that seeking ESI from Persern was unduly burdensome, cost prohibitive, and harassing when balanced against the scope of plaintiffs' claims. Plaintiffs pointed out that he was the founder of one of the defendants and had made public statements regarding the housing issue at Fort Bragg and other installations. Plaintiffs also questioned whether the apex custodian doctrine had been adopted in the Fourth Circuit and argued that defendants failed to demonstrate that adding Persern as a custodian would be an undue burden. North Carolina Magistrate Judge Robert Jones pointed out, as one court explained, argument that a party's senior executives are protected from being designated as custodians unless the party seeking such designation shows they possess unique personal knowledge or information about the events underlying the case appears to call for application of the so-called apex doctrine, which the Fourth Circuit has not adopted and which typically applies only to protect senior executives from attending costly and distracting depositions rather than from merely collecting and producing documents. He also stated, plaintiffs have not merely speculated, as defendants suggest, that Pacern is likely to have relevant information. Rather, plaintiffs have cited evidence that Pacern had made public statements, including in congressional testimony, specific to Fort Bragg and the types of issues raised in plaintiffs' claims. Thus, the court finds it is likely that adding Pacern to the ESI custodian list would render relevant information. He also rejected the proportionality argument, noting that plaintiffs' class allegations had not been stricken. So, Judge Peck, I've never heard of an apex custodian objection before. What is the apex custodian doctrine that the parties refer to, and does the apex custodian objection have validity in certain situations or courts?
I've heard of the apex doctrine in connection with depositions. Mm-hmm. I had never heard of it in connection with should somebody be a custodian. But in the Southern District in New York, among other places, apex doctrine for depositions is that unless that person has absolutely unique knowledge, they may have some knowledge, but if that knowledge can also be obtained from lower level employees or officers, that you don't go to the CEO or the highest level before you have exhausted all of that. And that makes sense. You know, if you're saying this is a case of police misconduct of some sort, something much in the news nowadays, and you take the police commissioner's deposition in every one of those cases because they had the ultimate authority to fire the officers involved or any other similar thing, they wouldn't have any time to do their day job. So that makes sense. But as we saw just 2 cases ago, you can collect a custodian's documents without even them knowing it. So there shouldn't be any burden on the CEO or the apex person from their documents having to be collected. So I don't see this as a doctrine that carries over to custodians and searches of ESI.
All right. Yeah, that makes sense. And interesting how those 2 cases have some similar aspects to them. So, Mary, one of the biggest potential areas of dispute in litigation is inclusion or exclusion of custodians. So what advice do you have for our audience on how to justify including custodians if they are disputed?
Yeah, I just want to echo that apex custodian for documents, you know, and not seeing that. I see exactly the opposite, that they're the frequent flyers and you collect them for multiple litigations. So you only collect them once. But to get more custodians, what I've seen is the ability to make arguments by a particular role, if they fall into a particular location, project, a product, a time period, if their name comes up in depositions or interrogatories, if they're CC'd or senders of relevant, important emails, doing a network analysis to see who communicates with whom, and what time periods are a timeline analysis for what timeline, what periods are missing where another custodian might be able to fill in. I've seen the people who did the job before them be raised after them, their support staff. And then in terms of something like a sales rep, demonstrating that each sales rep does their job differently, makes their own PowerPoints instead of using corporate approved decks that you can just collect from marketing. That expands. I've had the experience where that really dramatically, exponentially expanded the custodian pool.
Interesting. Yeah. Certainly a lot of different ways you can expand the list of custodians. Excuse me. Tom, I'll ask you the flip side of that scenario. What advice do you have for our audience on how to support objections to including custodians in a case?
Well, I think both Mary and Judge Peck touched on it, and Judge Peck referring back especially to the Linares case that we talked about above in the scope, time scope. So, you may have custodians who you think would be relevant, but were they in fact for the time that the claim or the acts that you're talking about occurred? So, for example, I was involved with a case a while back, a couple years ago now, but large Lanham Act case, online advertising, et cetera, large company, and the one side wanted the preservation and production of every email of every person who worked in the marketing department. Well, that was a very, very high number of people, over 60 people. So first of all, we said, well, let's see if we can determine that some people actually worked on the matter involving the plaintiffs in this particular case. Maybe there are a number of people who all have individual tasks. As Mary said, you got salespeople doing different things. You have marketing people doing different things. Who worked on this particular item? And we're going to deal with them. And were they working on it during the time period that you're interested in? Maybe they did some other ancillary work for this client preceding the claims in action. So, you have to look at not just the number of custodians and whether they have factual knowledge about the facts at issue in the case, but the time frame as well. And then I think again, specifically, if you're going to bring an apex custodian objection, it has to be a high-level employee. They have to have the unique firsthand knowledge of facts at issue, and you have to have exhausted all the less intrusive means of discovery. That is, have you gone to lower-level employees in an attempt to get it before you go after that quote-unquote apex employee?
Yeah, absolutely. And certainly, I've seen, people get very involved in the analysis of custodians in terms of relevance versus, cost, basically a proportionality assessment, of the custodians to try to help bolster their argument as to inclusion and exclusion. So that's certainly something I think we're seeing more of and should see more of, and hopefully will. Yeah, absolutely, a very interesting and common dispute in discovery. So with that, we'll go to our last case. And our final case points to data from a different collaboration app than we've seen before that's discoverable, which is Basecamp. So this case involved a fire that the plaintiffs alleged broke out because the defendant improperly remediated environmentally hazardous substances at the plaintiff's property, and one of the plaintiff's production requests asked for any notes, summaries, or any other documentation for all tailgate safety meetings conducted by the defendant. Those daily tailgate safety meeting documents were the defendant's form for its employees to fill out, review, and upload to defendant's web-based application, Basecamp, before each job to identify a particular job site's hazards, as well as reference meeting notes and so forth. The defendant responded that it had no responsive documents. But in later depositions, a defendant employee testified tailgate documents would have been used during the work at Bulk Chemical, and he testified he personally filled out 2 daily tailgate safety meeting forms for the Bulk Chemical job, as well as personally seeing daily tailgate safety meeting documents uploaded to Basecamp for the Bulk Chemical job. Also, the defendant claimed its employees were not located near the fire, but the plaintiff, Bulk Chemical, later produced surveillance footage of its facility showing one of defendant's employees located near where the fire started. Whoops. Plaintiffs moved for adverse inference sanctions against defendant for spoliation of Basecamp documents, contending that defendant either intentionally destroyed or lost the tailgate documents because defendant never produced the documents nor provided any justification for not producing them. And finding that spoliation occurred, Pennsylvania District Judge John Gallagher stated, defendant's policy requires employees to complete tailgate documents and upload them to the defendant's web-based application, Basecamp, before performing cleanup services, and is clearly relevant to the defendant's awareness of potential job risks. Defendant's non-production of the documents is sufficient to show there has been actual suppression or withholding of evidence. And lastly, defendant could reasonably foresee a duty to preserve the tailgate documents. Noting that defendant fails to provide any information concerning the circumstances of the document's non-production, he issued the adverse inference sanction. So, Mary, companies are using so many collaboration apps today, but that could lead to having to support them all in discovery, which could get really complicated. So should companies consider the potential discovery implications before deciding to use a platform? And if so, how do you recommend that they incorporate that into the purchasing decision process?
Well, Doug, that's a nice softball. Of course, they should consider the eDiscovery implications of a platform. My goodness gracious. So this can be done, as part of application justification. It can be a standard requirement in RFPs if RFPs are done. It's hard to do at the individual level with the shadow or a departmental shadow IT situation where people are going rogue. But in terms of the purchase decision, there's generally some form of security audit. And the threat surface and the cost of potentially being used in litigation, resulting eDiscovery costs, regulatory costs, data breach, privacy violations. That would be a good place for some of the risks to be quantified, or the cyber insurance carrier might have something to say about new applications. I think this is a place for our eDiscovery leaders, to flex their collaboration muscles with, their cross departmental tasks that they're and their mission critical tasks that they do allows them to create relationships. They may not have a seat at the table. They may not even know there's a table, but there is definitely a table where people discuss what applications are supported at the corporate level, and our legal tech people desperately need to be there.
Yeah, I couldn't agree more. And certainly, I think as we see more cases like this with platforms we haven't seen been involved in discovery disputes, it becomes more of an issue. So, Tom, certainly this is the first case I've seen involving discovery of Basecamp data. And of course, the defendant got sanctioned for failing to produce it. So with so many different collaboration apps in use by companies today, what advice do you have for supporting discovery from each of them?
Well, one thing I've always asked for and had not a whole lot of success over the years, to my surprise, I had one case where Craig Ball was a discovery master, and I was insisting that the client who I worked with give us a data map of all of their sites, locations, who what the software was at each location, who had access to it, et cetera. So I wanted not just a data map, but I wanted a data/custodian map. And it was a large corporation with multiple locations. When the case ended after about 3 years of my involvement, I still didn't have one. And this is, I think, a common problem with large corporations with distributed environments, that they're not always in touch. I could go to any one of those individual environments and ask the IT people there what they had, which is what we ended up having to do. And they were very knowledgeable, but nobody seemed to be in control or in touch with everything across the board. So I think the first thing is, as Mary suggested, to start getting your people to cooperate with each other inside the corporation and build those data maps. And you shouldn't have to do it in response to litigation. It would seem to me that a very dynamic, widely diverse corporation would want to know where their data is and how it's being handled in all the different locations where it's at, and go and start trying to build that. And I would recommend that, as an ongoing part of your info governance policy, is to have an up-to-date data map.
Yeah, absolutely. That certainly is important to make sure you know what you have. And, obviously there's shadow IT challenges. But if you've got an accurate data map, certainly one of the things I would want to do is kind of have a sense, at least a plan of understanding how I would get data out of it for discovery if it did come to pass. So, because there's more apps out there than ever, and each one of them is potentially discoverable. So it's going to get more complicated for discovery professionals than ever, which means job security.
And I should say part of the struggle, and it was part of the struggle in that case I mentioned, is the world of BYOD. You need to include in that what apps people are using on their personal devices for work-related activities, specifically things like Basecamp, or what messaging services are they using, and where are they putting them?
Right, absolutely, got to know that. So Judge Peck is noted by Judge Gallagher in this case. The defendant didn't even make an attempt to explain whether the documents were lost or destroyed. Should he have demanded a response first from the defendants on that question before deciding they were not only spoliated, but that there was also intent to deprive?
This clearly seems to be a motion that was fully briefed, not one of the, pre-motion conference. You write a letter, you come in before the judge, and then maybe you ask to submit full briefing afterwards. The defendant had the opportunity, it certainly appears from this decision, to provide any explanation if it had one. And, there is a limit to how much the judge can or should put a thumb on the scale and say, well, you didn't refer to this at all. You probably should have. I'm going to give you another chance. So no, I don't think the judge should have instructed the party to make an attempt to explain things.
Mm-hmm.
The other point I would make out, and interestingly, this case was the subject of an article in the eDiscovery monthly or regular article in the New York Law Journal. Maybe they filled out these forms by hand. It's not clear, but then they entered them into Basecamp. Now, I never heard of Basecamp before this, but it strikes me that now is ESI once it's in Basecamp, and that the court should have used the Rule 37E, E1, E2 analysis, and not just general Third Circuit case law on spoliation. But I think the result probably is the same either way you look at it.
Yeah, certainly interesting, and an interesting case. So certainly we've got a couple of questions from the audience. So one directed to you, Judge Peck. How does one get verification of the data provided by the third-party vendor through the party, i.e. to make sure nothing is withheld? And what if there is an issue of privilege asserted by the party? That's back to our third-party discovery case from a couple of cases ago.
Yeah, well, presumably the non-party, third-party, whatever we're calling them, is going to produce everything to the requesting party except whatever the other party may have asked to be withheld on the basis of privilege. And if it was withheld on the basis of privilege, that party should be preparing a privilege log for it. In addition, you have to rely to a certain extent on counsel, including counsel for the non-party, not wanting to lose their license. Just like if you ask a party, give me all your documents about X, you presume that they are indeed responding accordingly. A non-party has even less incentive to play games. But if necessary, it could be a bait stamp every document, list what you're giving to the other side for privilege review on a non-waiver basis. If the other party were agreeable, give it all to the party that issued the subpoena, and then let the defendant claw back under a 502D non-waiver order the material that's privileged. But in the normal case, the vendor is unlikely to be playing games.
Yeah, certainly would make sense. Here's another question to open to anybody. Have you seen alternate methods to access and collect online content that has been removed outside the Wayback Machine? So I guess it's content that's not there, but wouldn't be in the Wayback Machine either. Anybody have any thoughts on that one?
Well, I'll take a quick stab at it, from at least a partial stab. So the Wayback Machine doesn't collect everything. Right. You know, they're selective on what they do, but they do offer a service to collect it. So the first thing I'd find out is, are they, you know, I try to ask if the company you're trying to get the information from uses a private caching service or storage service or whatever of their online content, which could be the Wayback Machine, which means it's being done for them privately, or another company, which goes in and on a regular basis and you know, does screen grabs and you know, has affidavits of when they grab the information and put it. And I know several companies do that, and I know several companies have availed themselves of that. The second thing would be some sort of a request early on to find out if the company's doing that themselves internally. In several cases where I've been involved with clients who have very large marketing departments, I mentioned one earlier, they do that as a routine matter of course. They do it with advertising campaigns. They'll try to save that information. They may do it with specific employees. They may do it with specific products. I mean, it just could be different strategies. But the fact is, you know, is a department in the company or the IT department somehow preserving that information themselves, independent of any archiving and backup? Are they somehow grabbing that website information and putting it there? Then, of course, it's not as extensive anymore, but, you know, Google may be caching what a site looks like. And if it's been searched a lot, over the years, that information may be stored in the Google cache, which you can access. So that's worth taking a look at. I've actually found some good versions of sites going back a ways that were collected and preserved in the Google cache. So, you know, really, if this is sort of like, don't try to build that battleship at home, you might want to get a good forensics expert.
Sure, absolutely. No, those are some great thoughts and ideas. Obviously, some different approaches, and companies do save a lot of things, even things that are no longer on their website. So yep. Certainly always can get it, try to get it from the company some other way. So earlier I alluded to, speaking of spoliation and sanctions in this case, and since it's Valentine's Day, I alluded to the Lester v. Allied Concrete case, which Judge Peck reminded us of yesterday, which had some unique evidence that was spoliated, has a good lesson of what not to do, and a Valentine's Day theme, sort of. So, Judge Peck, would you like to say a couple of words about that one? To kind of give people a little perspective of an interesting case from the past.
Yeah, that was a wrongful death action brought by the husband of a woman his wife killed in the accident. He unfortunately had on his Facebook page a picture of himself with his arm around two young ladies, and he's wearing a T-shirt that says, "I heart hot mamas." His lawyer looked at that and said, I don't think that'll go over great with the jury. You're supposed to be in mourning for your wife, and you're wearing this T-shirt, and et cetera, et cetera. And the lawyer instructed, not hinted, not the client took it the wrong way, the lawyer instructed Mr. Lester to take down his Facebook page.
Ouch.
And the defendant in the case did not learn about this until after a very large jury verdict in the plaintiff's favor, resulted in a $500,000 sanction on Mr. Lester's lawyer. That lawyer was suspended, I think, for 5 years from the practice of law. And at least the gossip in the eDiscovery world was he never did come back from that forced vacation. So he wasn't disbarred, but it wasn't a good thing. And it wasn't a good thing for Mr. Lester's case recovery. I think, as much trouble as many lawyers are having with eDiscovery from Slack and, texts and whatever, I hope everyone has gotten the message now of you can't destroy evidence.
Yeah. And certainly lawyers instructing their clients to destroy evidence is especially a bad thing. Yeah, that was a very interesting case from back when. And thanks, Judge Peck, for sharing that. So we are a few minutes past time, and we recognize that. Here's the contacts page, and we do have a date for our next case law webinar. Yes, I know that March 28th is way after St. Patrick's Day, but some of us like to celebrate it longer than others. Until then, I will say thanks to Mary, Tom, and Judge Peck, as always, for their terrific insights. And I'll turn it back over to you, Mary, to close us out.
Thanks, Doug. I love that St. Patrick's Month. So if you'll take a look at the paperclip at the right of your console, you'll see our next webinar with the wonderful Ken Withers. What is a document? It's a journey through history there. And keep up with eDiscovery Case Law. That's Doug's blog, eDiscovery Today. Check out Tom O'Connor's Spicy Techno Gumbo. That's Tom's blog. Learn more about the Honorable Judge Peck and how you can engage him. Also, EDRM's professional responsibility considerations, AI for eDiscovery competence, confidentiality, privacy, and ownership. This is the public comment version. The comment period is about ready to close, and then there's a flash Valentine's Day survey for you as well. There'll be a certificate of attendance after the webinar that you can access for your continuing ed requirements. And thank you, Doug, for anchoring as always. Thank you to Tom O'Connor and the Honorable Judge Peck for this insightful presentation. And our thanks to the EDRM community for your kind attention. Thank you.
Thanks, everybody.
Thanks, everyone.
Bye-bye, all.